I'm Steven Svoboda. I founded Attorneys for the Rights of the Child in early 1997 to educate judges, lawyers, and the public about the need to safeguard children's bodily integrity and protect them from male circumcision. I'm very pleased to introduce David Llewellyn, who has brought about 50 penile injury cases over the past 2 decades. He's extremely knowledgeable about penile anatomy. He's an attorney based in Atlanta who handles cases throughout the United States.
Primarily, my practice involves suits surrounding the issue of circumcision, including wrongful circumcision cases where it's done without consent, botched circumcision cases where the child or adult is damaged because of the negligence of the parent, and occasionally injunctive actions to try and prevent the circumcision of a child when parents disagree. Well, there are a number of people, and of course the first would be the parents of a child who had been damaged beyond the regular damage of circumcision. In other words, if there's a negligently performed circumcision, say all the shaft skin is taken off or part of the glans penis is damaged, the parents of that child may bring a suit on that child's behalf, and also for the parents' medical expenses that they're going to have to expend while the child is a minor. That's one category. Another category is if a child was circumcised without the consent of the parent, and I've handled over 20 of those cases. It seems presently that most hospitals are now requiring a timeout like they always should have, so there are fewer of those cases today, but in the past they were really quite common. Then, in addition, if the parents find out that they were not properly informed as to the risks and disadvantages of circumcision, in other words, they weren't given all the facts, what is called informed consent, if it can reasonably be determined that a reasonable person would have refused the surgery if they had known all the facts, then they could bring a case against the doctor or whoever misinformed them under what's called the doctrine of informed consent. Finally, in some states, and it varies widely, we have 50 states in this country, 50 different laws, 50 different statutes of limitation, which are statutes that say you can't sue anymore. But in some states, a young man upon reaching the age of 18 can then still sue. The statute of limitations is added on to his age so that he can still sue if he's been damaged by circumcision. And another thing is this: if the parents, if a young man, parents or a young man find out that their doctor relied upon misinformation or lack of information provided by a trade organization such as the American Academy of Pediatrics, and therefore they were not fully informed, they may be able to bring a suit under what's called trade association liability against the organization that put out bad information, essentially to promote a procedure to help their members economically. Well, informed consent is a doctrine in the law that says that a physician who's going to operate on someone has a duty to make sure that the patient is informed of the risks, the benefits, and the alternatives of the particular surgery or treatment that the surgeon or doctor intends to offer. And the doctrine says that if the doctor fails in his duty, then if a reasonable person would not have undergone the surgery or the treatment, if that person had known all of the facts, in other words, if the doctor had told him everything, then he or she may bring a lawsuit on the basis of lack of informed consent. Not every state recognizes this doctrine in full. For example, my home state of Georgia does not. I think we may be the only state in the country that doesn't. But that is what the doctrine is. And so that if a parent finds that they have been coerced into circumcising their child and have not been informed of the risks and disadvantages of the function of the foreskin and the like, it might be possible to bring a lawsuit. There are a number of considerations that you have to take into account before you can determine whether or not you ought to file a lawsuit. That's why you consult an attorney, so that you can weigh the risks and disadvantages and advantages of filing a lawsuit. But that's the basic doctrine, and that's what it's meant to do. It's meant to make sure that patients are fully informed, because sort of our basic human right is the autonomy of our bodies and our control over them. and we certainly have a right to know all the facts before we let somebody else invade that body for any reason. Well, of course, the doctor who is negligent, the doctor who did not fully inform you, sometimes nursing personnel or hospital personnel, depending upon the facts. Assuming this is a circumcision damage case. Those are generally those who can be liable. There are also some other cases involving the genitals where folks can be liable. The foreskin is attached to the head of the penis at birth, and if a baby isn't circumcised, the foreskin won't become free for a number of years, and it varies widely. There are 2-year-olds where the foreskin comes back, and there are 15-year-olds where it doesn't. All of that is normal. There's a wide range. And a lot of times doctors or nurses will tear the foreskin back and seriously injure the child. If that happens, that's clear malpractice. I mean, everyone agrees that that should not be done, but unfortunately it's done pretty often. And sometimes in the right circumstances, something like that is worthy of a lawsuit. Well, it depends upon the facts. If a doctor has failed to operate within the standard of care, and that includes not giving you what we discussed about informed consent, he can be sued under medical malpractice. Sometimes it's called medical negligence, medical malpractice. Sometimes nurses can be sued that way, hospital employees and the like. If surgery has been done without consent, and consent is a difficult problem because were the parents fully informed in this sort of thing? Was consent obtained when somebody was not able to give consent, such as a woman who's just coming out of childbirth and is under anesthetic and this sort of thing? But if consent was invalid, then that would make what happened a battery. And there are other batteries that can occur, such as when a healthcare worker or a daycare worker tears a child's foreskin back. That's a case that can be brought to. Finally, there's such a thing as fraud, where someone intentionally tries to induce you to agree to a circumcision and doesn't tell you all the facts, or perhaps conceals the negligence that they have been guilty of, and that lengthens the statute of limitations. And finally, there's also the concept of trade association liability, and that would be, say, a doctor misinforms a parent about circumcision, doesn't tell the parent all the facts, and he has relied upon a statement from a medical association, say, that does not provide him with all of the facts and knowingly leaves out certain facts that are necessary to make an informed decision, then it's possible that that medical organization might be liable under what's called trade association liability. Well, that depends very much upon the state where the tort occurred. Statutes of limitations vary widely. Generally, the parents have a set time to bring the case on behalf of the child. Sometimes in some states, the child, when he becomes of age, can bring the case. In some cases, if the person who's been injured doesn't realize it, they have from the time of discovery. And in some cases, if a doctor conceals what he did and knew that it was wrong and knew that it happened and doesn't tell the patient, that fraud will toll the statute of limitations and lengthen it. So what is important is that the person with a potential case get to a lawyer who's knowledgeable in this area and find out what the statute of limitations is in that particular case. Well, in general, in any lawsuit where you've been damaged personally, where your body's been damaged, there are two types of damages. One is called special damages, and that involves medical expenses and other expenses that you have incurred or will incur as a result of the injury, actual out-of-pocket damages. And the other are called general damages in most states. They are pain and suffering, which includes the damage to your body, the physical and mental pain and suffering that you have incurred or may incur over your lifetime. So those are the two general types of damages. And one, of course, is very specific. That is what you've expended or will expend. The other is generally the pain and suffering award is left up to the discretion of the jury, subject to whatever limitations on damages may exist in the particular state.